budget, you've got two options. You've got Frontier, which takes you right into Orlando, $29 each way. Yes, I'm frugal about my tickets way ahead of time. Literally $29 each way. You do have to pay for your luggage. Or there's Risk Your Life Allegiant Air. So it just depends on how risky you want to be. But it's nonstop. There's no layover. So I literally try to go to Florida every weekend because I hate being cold in the winter. So I'm sad. I went to Disney, right? So I live for Disney. Don't judge me. I love amusement parks and rides. And I have an annual pass. So I went to Disney and it was my birthday, right? So when I was at the front, they're like, oh, it's your birthday. They're like, oh, here. So they give me this big, the pin, 5-year-old pin, right? It says happy birthday, Laura. So I was like, you know what, whatever. I'll go with it. No one knows me here. So I put the pin on. I got so much free stuff. They're like, they kept saying, oh, it's a magical moment. Happy birthday. And I was like, really? Starbucks, free latte. I mean, and then I was in line. They're like, oh, it's a magical moment. You can do the fast pass. I was like, what? So I felt bad. I told my mom, I said, it's going to be my birthday now every time. I'm going to wear that pin because I got so much free stuff. I'm like, this is really cool.
I got UV. Well, junior year of high school, we all went down to, my orchestra and band went down to Orlando to visit Disney World and the Orlando Studios, or not Orlando, Universal.
I know what you mean.
I need my computer to work.
So we ended up at Universal on the day of my birthday, and we were going through the Wizard World of Harry Potter, and we came across these very hot guys who were acting like they were from Durmstrang Academy, like from the 4th book, and they noticed that it was my birthday, and they're like, stop, we are taking you all to the 3 Broomsticks for lunch. It's on us. And I'm like, I'm okay with this.
Like they treated you for real?
Mm-hmm.
Okay, yeah, you got me beat on that one. Can I up her on that? I'm very competitive. Can I one up her? I need to stop being so competitive. I'm so competitive. All right, so, whoo, it's cold. Are we ready to get this over with? No, just kidding.
I'm frozen.
All right, so before we start discussing the worldwide Volkswagen case, I just want to do a recap on Schaefer just to make sure everybody's on the same page. We don't want any lost souls as we move on. So in recapping Schaefer, just a friendly reminder that the rule of law is that minimum contacts and fairness are now applied to quasi and rem jurisdiction cases. So again, just a friendly reminder. With Schaefer, the rule of law is that minimum contacts and fairness, which basically is that shoe test, applies to quasi and rem jurisdiction cases. Now, when I say minimum contacts and fairness, even though I don't physically say it, when I say minimum contacts, remember that also now includes the purposeful availment. Okay, so remember that's all part of the same test from Hansen. Okay, so we'll always discuss the ultimate rule of law in a particular case. I try to make sure I remember to make sure you know what the takeaway is. However, when we discuss the cases, it's really important, just as a reminder, that we understand the court's reasoning and the arguments for the cases. So I try to remind you all, because sometimes you're like, why can't we just talk about the holding, the rule of law, and move on? But really, part of the law school process is to teach you about thinking like a lawyer. You know, what arguments did the court find persuasive? Was it the plaintiffs or defendants, or why? So hopefully you'll start by the end of your 3 years of law school to see patterns, and you see, okay, courts tend to respond to arguments that are framed this way. So that's why in all your classes, just as kind of a rationale, we tend to focus a lot on the different arguments in each case and the court's rationale as well as what the ultimate holding is. So in Schaefer, as you might recall, the court's reasoning and the examples were all about whether or not applying minimum contacts test to in rem or quasi in rem jurisdiction would change the result of the case, right? And so they're basically just trying to decide whether or not this change was going to make a substantial difference in terms of how jurisdictional decisions were being made by the court. So we know the court in Schaefer said, yes, this change, meaning adding the minimum contacts and fairness requirement to quasi in rem jurisdiction, might change the outcome, but essentially what they said is it's in the spirit of fairness and the due process clause that we must change the test for quasi and rem because they felt like it upheld the principles of due process, which is fairness. And they didn't feel like it was fair for someone to be able to use quasi in rem jurisdiction to make someone come to another state if they didn't have minimum contacts. And again, a lot of the influence was trying to prevent people from moving personal property to some random state, knowing that I can't afford to come to Iowa and defend myself, and using quasi in rem jurisdiction to make me come there. Okay? So everyone's clear on the rule of law from Schaefer, right? Yay. All right, let's go on to worldwide Volkswagen. So I think we need 2 attorneys today, 2 bright rising stars. So let's do Attorney Baxter. Where art thou? Good morning. You're done. You've got such a big class. You should be happy. Baxter, there we are. And I usually do gender equity, but not today. And oh, I love this name, but it doesn't necessarily have to be a girl. Sydney Lane. Okay, Sydney it is. So I'm sorry, the reason I picked her name is Sydney, Australia is my absolute favorite city in the world. So sorry about that. All right, so we've got okay, so we got attorneys Sydney and Baxter. Yay. All right, let's do this. So, what are the facts in the case, either of you? Thank you.
So there's husband and wife, the Robinsons, and they bought a car from Worldwide Volkswagen Corporation, and they bought it while they were living there. And then they ended up moving to Arizona.
Yes.
And while they were driving there, they went through Oklahoma and were in a wreck. And the wreck resulted in a fire which severely burned the wife and her 2 kids. And so they ended up bringing a products liability suit against Worldwide, saying that it was a defective aspect of the car that caused the fire.
Excellent. All right, she gave those facts wonderful. They were detailed, they were precise, and she didn't start jumping to the holding. So kudos, thank you for doing that. Perfect, literally. All right, so this case is something that could easily happen today. It makes sense. You might buy a car in Kentucky, you're moving to Florida, and there's an accident on the way in Tennessee. So it makes sense that you might want to bring that lawsuit in Tennessee, where the accident actually happened. So did you all discuss products liability and torts yet? Okay, so this is a products liability case, and what they're thinking is that there's some type of defect in the gas tank. A lot of times with products liability cases, they don't know where the defect occurred. Was it in the manufacturer of the actual car part? Was it how the car part was actually installed in the car? So there's different chains along the way from the car's origins that might be responsible for the accident that we saw here. So that's why a lot of times in product liability cases, they'll have multiple defendants. So we know in this case, because of that, they joined a lot of defendants, a bunch of them. Attorney Baxter in the front there. Who are the potential defendants here?
They sued the manufacturer, the distributor, the importer, the regional distributor, and the actual retailer.
All right, so we've got Volkswagen, we've got Worldwide. Who's Worldwide? What are they?
They're the regional distributor.
All right. I should not have put this behind me because you're going to be able to see it and think that through. Volkswagen is going to be the importer. A lot of defendants. We've got the Audis, the manufacturer. And Seaway. Who is Seaway?
They're the dealer.
All right. These are all potential defendants. Voila. That's a lot. All right, so we know in this case that Worldwide and Seaway make a motion to dismiss for lack of personal jurisdiction. And the state court denies this motion. Oklahoma court affirms. So we'll learn later this semester that you can make these motions once a pleading has been filed for lack of personal jurisdiction. So that's why we're learning how do we know to make that motion. And so that's why we kind of do it in the reverse. We learn what personal jurisdiction is and then how to make the motion and get the case thrown out. So here, Worldwide and Seaway is saying, no. This court does not have jurisdiction over us, Your Honor. Motion to dismiss the case for lack of personal jurisdiction. Attorney Sydney, are we talking about general or specific jurisdiction here?
Specific.
Excellent. Why?
Because it has to do with the activities that
Whose activities?
the companies.
Plaintiff or defendant? You know the answer. So it has to do with the defendant's activities where?
In Oklahoma.
Perfect. All right. So specific jurisdiction, because the cause of action arises out of Worldwide Volkswagen's only contact with the state of Oklahoma, essentially selling a car that was driven to the state where it crashed. Because that's the only contact they have, so they're going for it. So the cause of action arises out of the defendant's activities within that state. It's a stretch, but we're saying the activities within the state is selling a car that ends up, again, getting driven to Oklahoma where the accident occurred. Any ideas, Attorney Baxter, I keep wanting to look up, why the plaintiff sued in Oklahoma and why not New York? Because remember, you can sue in the state where you're domiciled, right?
It's because they were moving to Oklahoma, and I think they settled in their new home, and I think they sued there because it'd be easier on them, and they thought they had jurisdiction.
Okay, good. Yes.
So I read in like the notes or something that Creek County was tough on, I think it was whatever the cause of action was, I forgot, maybe product liability or something. So that's why they wanted to do it in Oklahoma.
Okay.
And plus they had, been there in the hospital there and probably had witnesses there, so it's been medicine.
That makes sense. Yes.
Texas and Oklahoma are like known really well to be plaintiff favorable states, so it's just helpful to sue there.
True.
Absolutely. Did everybody hear all those comments? Okay, so your text doesn't expressly state the reason, but all of the pro-offered reasons I think are very reasonable and make sense. And so another reason that no one said is they wanted to make sure they could have the lawsuit somewhere where all of the defendants would be subject to jurisdiction. So only in Oklahoma, the way they looked at things, could personal jurisdiction be proper over all the defendants in the suit. Again, it's very expensive to go after these different defendants wherever they are domiciled or wherever you would have jurisdiction. So they were thinking if we do it in Oklahoma based on specific jurisdiction, meaning the cause of action arose out of the defendant's activities in the state, then we can have all of the defendants, and I'll get your question in a second, we can have all the defendants there at the same time, okay, based on specific jurisdiction. Each of them, potentially, the cause of action arose out of their activities within the state. Again, you could have two lawsuits, but very inefficient and expensive. Yes?
I'm still confused why two of them moved to dismiss for lack of personal jurisdiction, but the other two didn't, because they went after all four of them.
Yeah, so sometimes the others just didn't, they're like, we'll fight the lawsuit. We don't mind coming there to defend ourselves. It's just those two that said, we're not gonna do it. You don't have personal jurisdiction over us. So it's just a choice. The book doesn't, that would require, like, their attorneys, but we have to assume, meaning speaking with their attorneys, but we have to assume that they just didn't mind. And a lot of times with these big, great question, with these big corporations, like McDonald's, they're not gonna file for lack of personal jurisdiction. They have corporate attorneys in every state ready to address the frivolous lawsuits they have. Like my neighbor, who made a habit out of going to different McDonald's, looking for the little caution sign that's up and purposely falling.
Wait.
Yeah, or she would, move the sign, it wasn't visible. And she's just a scam artist. She never worked the whole time, our neighbor. She never worked. She lived off of those judgments. So the point is, certain companies expect people like my neighbor, and stuff is gonna come up. It's foreseeable, hint, hint, that they would be hauled into court in those states, so they don't bother to dismiss. All right, so why sue Worldwide Volkswagen attorney Sydney and Seaway, given that they already had Audi and Volkswagen of America, meaning they already had two deep pockets that could pay out, essentially. So why fight, and why fight this all the way to Supreme Court?
I mean, it's a chance to give you more money.
Yeah, so a chance to give you more money. What else, attorney? I keep wanting to look up Baxter.
Even if they found that the manufacturer wasn't at fault, maybe they found the dealer or the distributor was.
Excellent. So what, you want as much bang for your buck as possible. Any other ideas? Attorney, and I'm embarrassed that I forgot your name. I'm looking upside down still. 1, 2. Don't be mad, Demetrius.
Oh, me?
Why did they want to stay out of federal court?
I'm gonna stop talking now. Why did who?
The Robinsons want to stay out of federal court? Actually, you alluded to it as well.
Yeah.
Do you remember?
I
what you
have to
said?
look in the notes again.
Do you remember?
Yeah, just like the state courts are more friendly to plaintiffs.
Attorney Webb, right?
Yes.
Excellent. So yes. So they wanted to stay out of federal court because the state courts were much more amenable to plaintiffs. So remember I told you that federal courts, there's a reason why you pick federal versus state, and one of them is federal court judges have lifetime appointments, so they're less likely to be susceptible to the pressures of us saying this is a lawsuit against a local Louisville owned business, and we need to keep our local businesses intact and not let these big Walmarts come in here and cause problems. Whereas the state court, they want to be reelected. Those judges have to be reelected each term, so they may be more susceptible to community pressures. And so here, especially products liability claims, state courts tend to be more, we're judged for the people, so they tend to be more amenable to plaintiffs. And so the Robinsons do not want to get in federal court. And so they want to stay out of federal court, and if they would include Seaway and Worldwide Volkswagen, meant there wasn't diversity. What do I mean by that? So we haven't covered it yet, but because it's in the case, I have to explain it. We said that there's 2 ways to get in federal court. One was federal question, meaning to get a case where federal court will listen to it, federal question, which you remember was 1331 is the statute number, which again, we'll spend a whole week on this. And then the other way was diversity jurisdiction. So these are 2 ways you can get a case filed in federal court. So you have to have one of these requirements in order to file the case in federal court. So again, federal question, it deals with the treaty, a federal question, a constitution, like a federal question. So it's a First Amendment case. It's a 7th Amendment, Title VII, which is employment discrimination. So it has to deal with some type of federal question. Diversity jurisdiction requires that the plaintiff and the defendant be citizens of different states. And there's a little bit more, but that's all you need to know for this case. And so all that's to say, including Seaway and Worldwide Volkswagen would mean they wouldn't have jurisdiction, diversity jurisdiction, so then it couldn't be in federal court. So again, they're trying to keep it in state court. So they're like, we need to make sure that none of the defendants are citizens of the same state. So what was the plaintiff's, Robinson's argument in the case regarding the foreseeability of the accident and how that should lead to personal jurisdiction? Attorney Sydney.
They were saying that when the car was sold, it was foreseeable that the car would be given to Oklahoma or any state around there.
Do you think that's a pretty logical argument? Who says no? They don't think that should be a logical argument. Anybody? I think it's foreseeable that if you get a car and drive it, it could, if you sell a car, that it could potentially be travel to other states. It's kind of like the little scooters. It's large. You guys have Professor Rothstein? Yes. She's obsessed with these scooters.
Constant battle going on about those.
The scooter. She's obsessed. Every time I see her in the hallway, she wants to talk about the scooters. And you know, if those scooters are not on campus anymore, it will be because of Professor Ross. You guys think it's like, no, I'm not kidding. You need to win her over because she's eventually going to contact upper administration because she feels like it's such a liability problem and how they just drive anyway and how they drop them where they want, and then the ADA accessibility issues. Like, she's really obsessed with these scooters. I think they're cute. And I think they're amazing, especially if you need to get somewhere really quick and you're tired and you don't feel like carrying your stuff. How much does it cost each time you use it?
$1.25.
Oh my God, that's
I'm about to get one.
that is so good. So I personally love the scooters, but I mean, I imagine at some point in time though, would we need sidewalks that are scooter only, like, or where they split it, where the scooters are, like, cause how do you know, maneuvering around students walking, like, I see the tort, I mean, it's a great tort exam. It's like same thing as biking, but it seems like more people are apt, because bike, you've gotta ride it to school. I guess you're right, but the scooters seem more readily accessible, cause you don't necessarily have to have the money to buy a bike, you just pick up a scooter for $1, $2. I don't know, I like them, I'm just not sure how it's all gonna work. I think they're cool. It would be nice. Would you rather have like the carts? I think golf carts would be cool.
That
Take up too much space.
That I can tell you from experience, that is trouble waiting to happen.
I love
know
that.
this because we had a stage manager at a summer camp that tried to like literally run us over with a golf cart as a prank, but
Well, see, that's a prank. You can run somebody over with a scooter, but I like the idea. But we'll see. But the point is, please work on her, because she's gonna have them all snatched from campus. Because allegedly they don't have a contract with U of L. The scooters just started popping up.
that's true. They did just start popping up randomly, like especially around like Carpet.
I would need you, if you're on my property, I need to be getting a cut of the profit personally. So I'm surprised at U of L. I guess they're not paying attention, but Laura Rothstein is gonna make sure.
Aren't sidewalks public city property?
Yeah, that's what they do.
So-
They leave them public.
Oh, so they leave them in the,
Yeah,
oh,
they just like drop them outside of a store, but on the sidewalk.
but on the sidewalk,
Yeah.
that's brilliant. Alright,
This is a wild tangent.
yeah, it's a great tangent because this material is dense. Alright, so, I think the plaintiff has a very strong argument, which Attorney Sidney captured extremely well, which is that it's foreseeable that a car is mobile, right? And can move from one state to another. So worldwide, Volkswagen should foresee being sued in the state of Oklahoma because they placed a product in the stream of commerce. Okay, so what test did the court use in reaching their decision? Thankfully to us, they used a test we know, which is the minimum context test, which, again, purposeful availment plus fairness. So let's talk briefly, Attorney Baxter, about how the court addresses the plaintiff's foreseeability argument. What does the court say? Does they say foreseeability alone is enough, not enough?
They say it's not enough, and they cite Hansen about the unilateral activity about one person can't pull a defendant into a forum.
I want to just run over there and high-five you, but I'm tired. Great job. So yes, I'm going to read the direct quote from the case. It's important. It says, foreseeability alone has never been a sufficient benchmark for personal jurisdiction under the Due Process Clause. Now, I wrote that's on page 106, paragraph 4, but I don't trust my numbers sometimes. So again, foreseeability alone has never been a sufficient benchmark for personal jurisdiction under the Due Process Clause. I believe it's page 106, paragraph 4. So essentially what the court is saying is that under the due process analysis, the mere likelihood that a product will find its way to the forum state is not enough to satisfy minimum context, okay? But do they say that foreseeability is irrelevant? All right, Attorney Baxter.
No, they say it's not irrelevant. It kind of goes back to the whole, like, if you purposely do business in a state, you're availing yourself being sued in that state.
And what case is that reminding you of?
The
Or-
E case.
Excellent. So, beautiful job. Yay, so you're making the connections. All right, so they say foreseeability, yes, it is relevant foreseeability to some extent. The court says that due process requires, quote, directly from your case, quote, is that the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hauled into court there. I believe that's at the top of 107. The court says that the Due Process Clause gives us a degree of predictability. But the Oklahoma Supreme Court said that worldwide Volkswagen got substantial income from the fact that the car traveled to Oklahoma and thus benefited from Oklahoma law. I think that's a good argument. The time that you are driving in the state of Oklahoma, you're benefiting. There are roads and highways. If you need emergency personnel to come and assist you, the police department, while you're in the state of Oklahoma, you're under the protection. You are benefiting. So I think the Oklahoma Supreme Court is making a good argument with that. Oklahoma's argument is that because the car could and did go to another state, that's enough for personal jurisdiction. Who agrees with the Oklahoma Supreme Court stance? Yes. Why?
Well, like the whole time they were in Oklahoma, or when they got in that wreck and the fuel tank exploded, for example, it was the Oklahoma Fire Department that saved those people and kept it from being a wrongful death. So they're benefiting from the services in that state.
Absolutely. Yes.
I'm not sure I agree 100% with the Oklahoma Supreme Court, but I do know that one of the factors is what sort of interest the foreign state has in the litigation.
And Oklahoma had a very, very strong interest, and we'll talk about that in a little bit more detail. Thank you. So, all right, so we know the Supreme Court says it's not enough here. Again, them benefiting from Oklahoma's protection, fire department, as he stated. And again, why? Because there's no purposeful availment. So again, as Attorney Baxter was saying, the court has a very strong aversion to unilateral actions that create a personal jurisdiction for a defendant, meaning someone else's actions. So the court says no purposeful availment because, again, the facts show that the defendants carry on no activity whatsoever in Oklahoma. Remember in the international shoe case, that was a different story. They did carry on activities within that state. But here, no activity whatsoever in the state of Oklahoma. They close no sales in Oklahoma, perform no services in Oklahoma. They solicit no business there. So again, the court says simply placing the car in the stream of commerce is not enough. But then the question that we care about is what would have constituted enough contact to meet that minimum contacts test. I believe the third paragraph on page 107, the court says, quote, the forum state does not exceed its powers under the Due Process Clause if it asserts personal jurisdiction over a corporation that delivers its products into the stream of commerce with the expectation that they will be purchased by consumers in the forum state. So does that apply to the defendants here? Were they selling or marketing products to Oklahoma residents, Attorney Sidney? No. The court says no, it doesn't apply. Again, Seaway's, the actual dealer's sales were made in New York. Worldwide marketing was done in New York, New Jersey, and Connecticut. They did not try to solicit any business in the state of Oklahoma. So, Attorney Baxter, on the issue of minimum contact, what does the court conclude and why?
They said that neither defendant has the minimum contacts in the state, and so they can't assert personal jurisdiction.
Excellent. And one thing they consider too is that the court talks about, the witnesses were there, Oklahoma law should apply. They talk about, as Jessica was saying, the state of Oklahoma's strong interest. The plaintiffs are now near Oklahoma, meaning their new home a lot nearer than New York was. So the court still says no. But remember, there's still that fairness prong. This is the whole reason we read this case, because they give us another rule to add to our how do you determine if there's personal jurisdiction. So finally, unlike International Shoe, who just said you need minimum contacts and fairness, the court in this case tells us how do you determine fairness. They give us these 5 factors. What are the 5 factors, Attorney Sidney?
They are the burden on the defendant, the state's interest in adjudicating, the interstate judicial system's interest in the most efficient resolution of plaintiff's interest in obtaining and effective relief, and shared interest of safeguarding fundamental substantial social policies.
Excellent. So I've never had a civil procedure exam and not ask you about the 5 fairness factors. Why? Because when you're attorneys and you're trying to determine if there's personal jurisdiction, you need to know these factors, because if one of those are not present, you can make an objection and try to have the case dismissed for lack of jurisdiction, right? And so I got your email, I'm glad you made it. So, let's talk about these 5 factors. Number 1, burden on the defendant. So you're just gonna consider how much is it a burden on the defendant to have to travel from Arizona to Oklahoma, for instance, to defend themselves. So what's the burden on the defendant? To come again to this state in which they're not a resident to defend themselves in this litigation. Number 2, the state's interest in adjudicating the dispute. Well, we've already talked about Oklahoma has a very strong interest in adjudicating the suit. Unfortunately, the Supreme Court in this case disagreed with our argument that Oklahoma had a strong interest. And it would be more fair to have the case in Oklahoma. But the point is, as attorneys, you're going to use these 5 factors to write your argument to the court and your brief that you submit on why it would either be fair if you're representing the plaintiff, or if you're representing the defendant. You're going to use these 5 factors to say why it goes against traditional notions of fairness to have the defendant come and defend themselves in that suit. So you use these 5 factors to build your argument, and then the judge will make a ruling. The 3rd factor, the plaintiff's interest in obtaining convenient and effective relief. What do they mean by convenient and effective relief? Well, where did the accident occur, the cause of action? Where are the witnesses located? And we'll have some more cases that apply this. What's each the plaintiff and defendant's proximity to the state of Oklahoma? Let's say the plaintiffs now live in Arizona, and then say 3 of the defendants now live in what's outside of Oklahoma?
Texas.
Nebraska, pretty close.
Sort of Kansas.
Kansas. Oh, Laura. Yeah. So Kansas, right? So that would be something you would consider in terms of the plaintiff's interest in obtaining convenient and effective relief. The 4th option, interstate judicial system's interest in the most efficient resolution of litigation. That kind of overlaps with the 3rd item. Again, when you're thinking about efficiency, you're looking at where the accident occurred. Why does that matter? Because a lot of times, like we're going to read a case later on where it's a plane accident. Well, the plane wreckage, you can't really move that to, so people, so if you have the lawsuit in a state, in say Ohio, and the plane wreck in California, then their experts are going to have to fly to California to look at the wreckage. So that's something they would consider, as we'll see in this case later on down the line. Where are all the witnesses located? Well, the fire personnel that put the fire out on the plane that crashed, the eyewitnesses that saw this mysterious smoke coming out of the top of the plane as it was descending to crash to the ground. Like, it would not be efficient to have to transport all those witnesses to another state, meaning outside of where that accident occurred, to testify in court or whatever. So they try to consider all these different factors in determining which state. Now let's pause just for a minute. When you first learned that first week about personal jurisdiction, did you think there was going to be all these things to consider? Because before I came to law school, I thought, you file a case in whatever state that you live in, and you just kind of move on from there. Like, I didn't realize there was so much to consider in terms state versus federal. What if someone doesn't want to defend themselves in Kentucky and they live in Ohio? Like, there are a lot of moving parts. I'm glad that the court is addressing this, but imagine what things look like, the legal landscape, before we have these rules. Yikes. Just yikes. Lots of default judgments. And then the 5th and final one, we will rarely see in Civ Pro 1, but you'll see it in Civ Pro 2, is the shared interest of states in furthering fundamental substantive social policies. So, shared interest of states in furthering fundamental substantive social policies. So it might include stuff like family harmony, marital harmony. Again, we won't cover that 5th one here in our class, but so if it's a divorce proceeding, and maybe, the kids are located in Kentucky, the divorce is in Ohio, so they'll consider things such as, the mom trying to go back and forth because the dad has brought the suit in Ohio, but the kids live here in Kentucky, child care, the expense of uprooting the kids. So they will consider kind of these external factors that deal with kind of substantive policy. They just mean for the greater good, essentially. So again, that's a very subjective criteria, that fifth one, just to give judges some discretionary power in terms of trying to make sure fairness is being upheld. So just really quickly again, those 5 factors that are guaranteed to be on your exam: burden on the defendant, number 1. Number 2, the state's interest in adjudicating the dispute. The third one, the plaintiff's interest in obtaining convenient and effective relief. The fourth is the interstate judicial system's interest in the most efficient resolution of the litigation, such as where the witness is located. And then fifth, shared interest of states in furthering fundamental substantive social policies. Okay, so why does the court not do, Attorney Sidney, a fairness analysis in this case? I think you can find it on the second paragraph on page 106. I believe. Again, I didn't check my page numbers. Why did the court not do a fairness analysis in this case? Because we know it's required.
Because they said that the defendants didn't bill themselves with another villages, so it wasn't necessary.
Right, wasn't necessary. Why? Because there was not, give me the buzzword. Since they didn't, say it again?
I was asking you to repeat yourself.
Oh, so give me the buzzword. So you said, and you were correct, the defendants did not personally avail themselves to the benefits of Oklahoma, which means they didn't have minimum context. Yes, so I'll read from your text. It says, quote, "The due process clause does not contemplate that a state may have a binding judgment in personam," and again, I believe this is on page 106, "against an individual or corporate defendant in which the state has no contacts, ties, or relations, even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has a strong interest in applying its law to the controversy, even if the forum state is the most convenient location for the litigation. The due process clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment." So what does all that lengthy legal jargon mean? It just means that relevant contact is absolutely necessary before fairness is assessed. So if you don't have minimum contacts, there's no point in doing a fairness analysis, the court is saying, because the outcome is going to be the same. So again, just meaning that you do need minimum contacts before you address fairness. In this case, the court concluded no minimum contacts, so they didn't bother to address the fairness prong of the test. For exam purposes, I want to know that you know the whole test. So even if there's no minimum contacts, if that's your argument, still explain, if there was a fairness argument, what it would be. So for the purpose of the exam, go through the whole test, all the steps. Talk about minimum contacts, talk about purposeful availment, and fairness. So let's talk about Justice Brennan's dissent. Attorney Baxter, your thoughts on the dissent? Either tell me your thoughts or what's he saying. And take your time.
I skimmed the dissent, so.
No, I usually don't ask the dissent. That's why I said take your time. So
Okay.
skim through it. You're obviously prepared for class, so I'm not going to harass you. So anybody's thoughts on Brennan's dissent? Yes, thank you.
I do kind of agree a little bit more with Brennan in saying that, Oklahoma had a very strong interest in, keeping its highways safe and, protecting just the interest of the plaintiff who was involved in the accident.
Excellent. So yes, Oklahoma does have a strong interest in enforcing its highway laws, right? I do think I agree with Brennan that the court really downplayed, or rather didn't give enough credence to Oklahoma's interest in the outcome of this litigation. I mean, think about the state of Oklahoma. If you drive through my state and there's an accident with one of my residents, I don't want them to have to fly to another state, to get redress. As my state, I want you're driving in my state, you have an accident with one of my residents, you need to come here and defend yourself. What do you think about that, Attorney Baxter?
I kind of agree with them. I do think they kind of skew international shoe a little too narrow.
Absolutely. And clearly they acknowledge that the state's interest in the outcome of the litigation is one of the factors you consider for fairness, yet they said we don't care. Again, if there's no minimum contacts, we are not even going to address the fairness problem. So that's essentially what's happening here. Yes?
And then there's also the policy argument in that all of these defendants are, big guys with big money, and this family, this little old family, they're in transition, and they have this accident. It wouldn't be fair to make them, go to where the defendants who are a lot more capable.
Have a lot more resources. So that sounds like a compelling argument that you would make before the judge to pull at he or she's heartstrings on why they shouldn't let these big bad corporations take advantage of the little guy. All right, so that is our Volkswagen case. So I'm going to do a quick summary to make sure we got the important stuff out of the case, and then we'll move on to Burger King, and then I have a political question for you. It's kind of a joke, so it's okay, it's safe. All right, so in summarizing worldwide Volkswagen, we know that International Shoes Minimum Contacts Test, again, we're reminded, consists of two parts, contacts, which includes purposeful availment, and then fairness. So they have reminded us of that. Another black letter rule from this case is a relevant contact is absolutely necessary before fairness can be assessed. So a relevant contact is absolutely necessary before fairness can be assessed. Gotta have a relevant contact. So they're not gonna fine for personal jurisdiction. Essentially, if it's unfair, but you still don't have a contact with the state. So again, a relevant contact is absolutely necessary before you can assess fairness. Another important takeaway from this case is that there must be purposeful availment and foreseeability. So now you see we've added yet another component to our test. Now we've added foreseeability. So there must be purposeful availment and foreseeability, meaning it must be foreseeable that the defendant would get sued in this forum, not just that the product could possibly end up in the forum. So again, you must have purposeful availment plus foreseeability. So it must be foreseeable that the defendant would get sued in the forum. Okay? Must be foreseeable that the defendant would get sued in the forum. And then last but not least, we love this case because it set out the 5 factors to be assessed for fairness, right? Whether it's the 5 factors to be addressed to assess whether or not it would be fair to allow that state to exercise jurisdiction over the case. So it set out the 5 factors to consider whether or not it would be fair for that state to exercise jurisdiction over the case, personal jurisdiction. Just letting the handwriters have a little time to finish. So studies show that when you handwrite your notes in class versus typing them, that you retain the information better. And I knew that in law school because our teacher kept saying that, but I just was lazy, and I'm like, I'm not going to do that because it takes longer and it's more work. But sometimes I wonder if it would have changed the outcome of, like, if it would have got a half a letter grade higher or not. I don't know. That's what the research says. All right, Burger King. So my joke was, just out of curiosity, who thinks that it was a good idea for President Trump, our current president, to have Burger King for the Clemson football players when they came to the White House? I thought it was hilarious.
That's terrible.
I was dying.
I thought he was trying to be cool or hip, like, oh, they're college kids, I'm gonna have fast food. Like, I think he was trying to be cool and not
They
offensive.
already eat that.
Yeah,
It's like the way you're like creepy uncle trying to be cool.
That's
I don't-
the
I-
worst.
I was cracking up. I was
I
on
just
the
thought it was
floor.
hilarious that was considered news. I'm like, really? This is news with all the stuff going on in the world? Burger King?
I thought it was funny because
Get you a juice at the cooler.
Didn't have food, Buzz Light, but you paused to shut down.
Trump Tower's still open.
Regardless of the rationale, I just thought there's more important stuff to talk about in the news than fast food at the White House. And I thought he was just trying to be, like she said, the cool uncle, which we've all had parents try to be cool in high school where it's not cool. We're like, don't do that. Just drop me off. Don't walk me up. I don't need you to walk me up to the door. My mom was notorious for that stuff. Just notorious for embarrassing me. She had a blowhorn at my track meets. Like, for real. They created a rule because of her blowhorn, and now says you can't do them because she's, come on, you got it. You can beat her. I was like, really? She was like terrible. So I thought about it because of the Burger King case. So let's talk about good old Burger King. We are happy because you notice the cases are getting more current. Yay, we got 1985. We're in Cyndi Lauper. We are. Most of you probably don't know who she is, and that's okay. But we're in the what do you call them? The leg warmers and flash dance era. All right. So, Attorney Baxter, the facts, since she gave us the last one. Thanks.
This case arises out of Burger King terminating one of the franchises, which was called a divorce proceeding among commercial partners, which I thought was funny. It happened because the appellee, whose name I'm not going to try to say, was a Michigan citizen and a senior partner in an accounting firm, and the son of one of his business acquaintances suggested that they open up a Burger King together. The son would be the restaurant manager, and the appellee would just, run the money side of things. And Burger King has their headquarters in Florida. Yep. I don't think it said where they were,
Miami.
incorporated. And the only real contact they had was where the son would go down there to do training, but they ran into a lot of problems early on. They disagreed on a lot of stuff to do with the restaurant, and then business faltered and fell behind, and Burger King sued in a federal district court in Florida.
Perfect. So, I must say you have briefed your case to the max. It's really, really impressive. All right. So, Burger King. So, I'm going to just highlight some of the important stuff of what she said. A, we care about the fact that it's a Florida corporation, right? Incorporated in good old Miami. So, Florida corporation, Redesheritz, which that's how I'm going to say it, I don't know how to pronounce it, is a Michigan citizen, and they enter into this 20-year contract to open a Michigan franchise. So, that's what we care about, okay? The contract is governed by Florida law, that matters, but supervision will take place at the Michigan District Office. So, governed by Florida law, supervision will take place at the Michigan District Office. Burger King, as she stated, sues Redesheritz and Max Shara, their business partners, in federal court for breach of the franchise contract because they failed to make payments. Okay, you can't do that, so they got to breach a contract suit. So the issue in this case is what was the defendant's initial response to the suit? I'm sorry, what was the issue in this case first? Attorney Sydney, Australia. Yeah, so whether or not Florida has jurisdiction over Redesheritz and his McShara, I think it was. McShara, yeah. Okay, so what was the defendant's, what were their initial response, Attorney Baxter, to the suit by Burger King in Florida? What did they do?
They tried to get it thrown out because Florida didn't have personal jurisdiction.
Yeah, they're like, Your Honor, I need you to dismiss this case for lack of personal jurisdiction. So the first thing the defendants did is challenge jurisdiction. They said they challenged it because, why, Attorney Sydney? What was their argument on why Florida doesn't have personal jurisdiction over them? Okay, why not? What specifically from the facts? Why are they saying, hey, you don't have personal jurisdiction over us in Florida?
They conduct all their business in Michigan, not in Florida.
Okay, that's one. What else?
All the people they met with regarding the business were from the Michigan headquarters there.
Where are they citizens? Where are they domiciled? Yeah. All right. So strong argument here. They're saying, look, we're Michigan residents, and Burger King's claims did not arise within Florida. So they're basically saying there's no specific jurisdiction. So they're saying, look, Florida doesn't have jurisdiction over this case. I need you to dismiss it. If we look briefly just at the procedural posture for this case, we know that the district court says, yes, there is personal jurisdiction. and the plaintiff Burger King wins at trial. Then they appeal it to the 11th Circuit Court, and they say no, there is no personal jurisdiction. They reverse, saying that personal jurisdiction would be unfair to registrants. And then the Supreme Court disagrees, flips it again, and says no, 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 personal jurisdiction does indeed exist. So I say that in terms of highlighting the procedural posture. You can see why the Supreme Court needed to step in here, because there was a lot of uncertainty and ambiguity in terms of this particular aspect of determining personal jurisdiction when it's dealing with a contract, right? So we know ultimately, yes, Supreme Court says there is personal jurisdiction. Let's talk about why. So if you're relying on minimum contacts to establish personal jurisdiction, you need to determine whether you're talking about specific or general jurisdiction. So Attorney Baxter, which type are we talking about here?
General?
Okay, tell me why. Remind me what general jurisdiction is, even though we haven't really covered it yet. What type of context do you need?
The minimum contract? That is wrong, yeah.
Yeah, if it feels wrong, don't go with it. So general jurisdiction, we need what kind of context? Someone just yell it out. Go ahead. Substantial context. So do the defendants in this case have substantial contact with the state of Florida? Okay, so there's no general jurisdiction then. So what about specific?
Yes, they do have minimum contracts.
Okay.
Because they negotiated a contract, they entered into a carefully structured 20-year agreement, and the court says, even the contract says all suits must be filed in Florida, so they knew they were gonna be sued in Florida.
Okay, and what else can you define specific jurisdiction? So I always start out with that before you apply the minimum contact test. You know what it is. You've been in rock star mode, and you've got the fancy book holder. You got this.
My definitions.
Well, I know that you know it without looking at the computer because you're too prepared not to. I know that you know it. I feel really confident. So, does it matter where the cause of action occurred? Or how it occurred?
Is specific, yes.
Yeah, so how does it happen? Where does it have to occur?
It has to occur with the thing that,
You do know it. The cause of action arises out of whose contacts?
the defendants,
Contacts with?
the forum state.
Yeah. So remember, specific jurisdiction is just the cause of action arises out of the defendant's contacts with the state. So here, yes, there is specific jurisdiction because the, again, case at hand arises out of the defendant's contacts with the state, specifically meaning Burger King's suit against the defendant is based on the contract which was entered into in the state of Florida, and which was not breached in Florida. So the question in this case is, where do you draw the line in terms of the amount or level of contact with the forum state that's sufficient, right? So how much contact is necessary to satisfy this minimum contact in a case dealing with a contract? And so what the court says is that the contacts cannot be pervasive. They have to be continuous and systematic, essentially is what they're saying. So it has to be continuous and systematic. So that's the level of contact you need. So we like this case because previously all we knew is minimum contacts with the state, meaning the non-resident defendant needs to have minimum contacts with the state. Now we know, even though I mentioned in an earlier class, you see where I got it from, that contact has to be systematic and continuous. So that's the level of contact. So when you're making the argument for the judge, you're going to say Professor McNeil's contact with the state of Kentucky is systematic and continuous because she has a lease in the state of Kentucky. She pays car insurance in the state of Kentucky. She works in the state of Kentucky, and so on. All right, so this is where it gets a little interesting. What does Brennan's... Oh, I forgot to mention that. We're going to have to come back to that. That's super important. All right, so the court is basically saying three things here about minimum contact. Thought about something I missed from the other case. On page 114, third paragraph, Tell me if I'm right. Section 1A. Do you see where Brennan says about minimum contacts and the issue of foreseeability? So page 114, third paragraph. Someone give me a thumbs up if I'm giving you the right page.
And what was the? See what
Brennan?
Brennan says about.
Yes, all right, cool. All right, so I forgot to mention this earlier, but it's important. So in the page 114, third paragraph, Justice Brennan has a lot to say about minimum contacts and the issue of foreseeability. He cites the worldwide Volkswagen case that we just covered and says that the foreseeability that is critical to due process analysis is the defendant's conduct and connection with the state are such that he should reasonably anticipate being held into court there. Brennan goes on to say that the foreseeability of causing potential injury in the forum state is not enough. That's important. So the foreseeability of causing potential injury in the forum state is not enough. Brennan goes further and tells you that foreseeability, he reminds you alone, is not enough. You also need purposeful availment. So in the second paragraph on page 114, the court says, quote, where a forum seeks to assert specific jurisdiction over an out-of-state defendant who has not consented to suit there, this is fair warning that the requirement is satisfied if the defendant has, again, purposely directed his activities there and the litigation alleged injuries that arise out of or relate to those activities. This is essentially specific jurisdiction. So what's important from that section is the court is basically saying three things here regarding minimum contacts. The court is saying three things regarding minimum contacts, and I highly recommend you write them down. First, the court is saying that random attenuated contacts with the forum state are not enough. So the court is saying three things about minimum contacts. First, random attenuated contacts with the forum state are not enough. So random attenuated contacts with the forum state are not enough. And again, I'm slowing down for the handwriters. Random attenuated contacts with the state are not enough. Second, unilateral activity of another party or third person is not enough. So unilateral activity of another party or third person is not enough. And as Attorney Baxter said, we got that from the Hansen case. So the unilateral activity of another party or third person is not enough. So when you're looking at a fact pattern on my exam and the bar exam, you're not going to fall for these three things. You're going to look and see if the contacts in the fact pattern are the result of a unilateral activity by one of the parties. You're not going to miss this. Number three, actions by the defendant himself, and I emphasize himself, must create a substantial connection with the forum state. So again, the court is saying that actions by the defendant himself, has to be the defendant, must create a substantial connection with the forum state. Yes, ma'am.
That wording is a little confusing because substantial would imply to me general jurisdiction, not specific.
Substantial connection, not contacts. So again, actions by the defendant himself must create a substantial connection with the forum state. And that just means that the defendant deliberately engages in significant activities within the state, creating continuing obligations. So it just means the defendant deliberately engages in significant activities within a state, creating continuing obligations between himself and the state. Such that, thought the sentence was over, huh? He has purposely availed himself or herself, such that he or she has purposely availed themselves to the benefits of the state. He or she has purposely availed themselves to the benefit of the state, and this is the last and can foresee being held or hauled, H-A-I-L-E-D, held into court in the state, So, number 3, actions by defendant himself must create a substantial connection with the forum state. Defendant deliberately engages in significant activities within the state, creating continuing obligations between himself and the forum state, such that he or she has purposely availed themselves of the benefits of the state and can foresee being hailed into court in the state. Can foreseeably see being hailed into the court in the state. Do all my handwriters have that? Awesome. All right, so in other words, the rule is just because there is a contract with an out-of-state party does not necessarily mean there's automatically personal jurisdiction. So just because there's a contract with an out-of-state party does not mean there's automatically personal jurisdiction. Instead, you look into the acts surrounding the contract. So you look at negotiations, the terms of the contract, the course of the dealings, to determine purposeful availment prong. Okay, so again, if you see any fact pattern dealing with a contract and you don't automatically assume because the defendant is out of state that there's automatically personal jurisdiction. The judge is going to look at the acts surrounding the contract. Where was the contract entered into? How long was the contract for? Here it was 20 years, I believe. Where were the negotiations taking place? And so on. So those are what you look at to determine the purposeful availment prong, which makes sense. If you're going to a 20-year contract to do business with someone, you're probably purposely availing yourself to that state. That's a long-term, continuing, substantial connection that you're going to have with the state of Florida. 20 years is a long time, right? So it makes sense. You look at the circumstances surrounding the contract. As you saw from the Volkswagen case, this purposeful availment requirement is an absolute minimum before you assess the fairness prong. Okay, if you can't show the defendant has, by his or her own conduct, created a connection with the state, the forum, then there can be no personal jurisdiction over that defendant. Unfortunately for us, the test does not stop here. After we determine again there's purposeful availment requirement or minimum contacts requirement has been met, that's when we look at those 5 factors from Volkswagen to determine, so fine, they have minimum contacts, but would it be fair to force that non-resident defendant to come and defend themselves? So when we look at the reasonable factors that you consider for fairness, remember it's those 5 factors: the burden on the defendant, plaintiff's interest, and so on. Let's consider those factors with the facts in this case. In part 1B of the case, 1B as in boy, the court applies those 5 factors from Volkswagen to the facts here. We know, yes, they find that there is personal jurisdiction. How did the defendant, attorney Sidney, purposely avail himself to the benefits of the state of Florida? Why are these acts here enough?
Because they did a training course in Miami, and they bought equipment from Miami, and entered into the contract with the company in Miami, like sent payments to Miami.
Absolutely. So we know that, remember one of the things I said you look at it when it's a case dealing with contacts, is negotiations. So where did the negotiations occur? With whom? So the negotiations were with a Florida corporation for purchase of a franchise. The direct negotiation, granted, was by letter with the home office because it decided those big issues. So even though all the face-to-face and oral contact was with the Michigan office, and the franchisees never sent mail to Florida and applied for a franchise at the Michigan office, the court said they had to consider they never visited Florida. They never actually visited Florida. But physical presence, again, is not necessary in modern times like it was during Neuer. So the court said, again, the acts here are enough because negotiated, again, with the Florida corporation for the purchase of the franchise. Number 2, they envisioned an ongoing relationship, right? They signed a 20-year contract with Burger King in Florida. So that's another reason the court said, yes, it would be fair. They knew there was going to be a long-term connection. Again, 20-year contract. 3, the court said they looked at the contemplated consequences, right? They said it's foreseeable injury to a Florida corporation by refusal to pay your payments. It's foreseeable that you're going to injure this Florida corporation. And then lastly, there are certain provisions of the franchise agreement in the contract that they felt were relevant to the state of Florida in terms of Attorney Baxter mentioned earlier, like for instance, there was a clause that said in the event of an arbitration clause, in the event of a legal dispute, Florida law will apply, right? So they also looked at the terms of the contract. What are the relevant provisions of the franchise agreement that the court really hones in on Attorney Baxter? And what specific contract terms? Some of them I just mentioned. It's in the second paragraph of page 115. What are the relevant provisions of the actual contract the court really hones in on, focuses on?
The part about how cases have to be filed in Florida, and then how that is a 20-year contract and all that stuff.
Yes, so contract made in Florida. Florida law applies, right? The court says that the Court of Appeals gave insufficient weight to these provisions in the contract, which again makes sense to me. So if you decide to do contract law, it's very strategic when you're engaging in a contract with someone. Whatever law, to put that clause in there, an arbitration clause that says Michigan law applies, Kentucky law applies, whatever law that you want to have to litigate that suit, it doesn't guarantee, but it increases your chances. You want to put that in the contract. Kentucky law governs in the event of a dispute if you're doing a contract with a non-resident, out-of-state person, okay? So let's apply the fairness factors in this case. Let's try to apply them to make arguments for the parties. I'm going to go through them really quick. What arguments are there regarding Florida's interest in this case, okay? What's Florida's interest? Well, it's the interest of the forum state, Florida exists, even though Michigan may also have an interest in the suit. You can make the argument that Florida is saying, look, you know, we want, if our residents engage in contracts with out-of-state people and they breach on their contract, we don't want our residents having to travel to defend themselves when, you know, they're not in the wrong. So that's one of Florida's interests. What about interstate judicial system's interest in a quick resolution? There's no support in this particular court record that Michigan witnesses could not be called to appear in Florida case. Besides, this can be addressed with a change of venue motion, which we haven't covered yet, but the point is there's nothing that says in the case that indicates it would be difficult for these Michigan residents to come to Florida that might be witnesses for the case. If we were to look at the facts in more detail, we can make the argument, you know, the eyewitness for this particular contract, they were there. Our senior manager was there when the contract negotiations were taking place, and you know, the defendants were assured that any litigation, despite that clause, would happen in Michigan, and he can testify to that. They verbally said that during the negotiations. But this person now has congenital heart failure, and he's not able to travel. So that's something the court would consider. That is their star witness. He's not able to travel. But based on the record we see, there's nothing to indicate a barrier to the Michigan witnesses, whoever they might be, traveling to Florida to defend themselves. The other thing, the plaintiff's interest, meaning Burger King, if you look at interest in meaning the litigation or the outcome, if you look at the top of page 116, the court says there's nothing in the record showing a disparity in bargaining power or fraud. They said, yes, we acknowledge that Burger King is a major corporation, but apparently the defendants are pretty savvy business people as well. The harm Burger King suffered is also in Florida. So someone mentioned earlier, I don't remember who it was, you know, a lot of times these big corporations will try to make, you know, the little guy come and defend themselves in California. The court will consider that, meaning who has the most, who has the resources that have the least amount of inconvenience. Here they're saying, look, these aren't just the little mom and pop owners. These are savvy businessmen. They tried to get over. They didn't fulfill their obligations. They can travel. There's not a huge difference in bargaining power here. And then lastly, with respect to whether there are any substantive social policies that are relevant to this fairness assessment, the court says no, not really. Not really any substantive policies to consider. So I want to just briefly end by discussing Justice Stephen and Justice White's dissent. For future references, some of these cases, if they have significant dissents in them, make sure you know in like just with maybe 2 to 3 sentences what each justice said, because I will ask you about the dissent. Since a lot of times I think the dissent is right, meaning based on my perception, so I just like you to consider other ways that this case could have come out. So in terms of Justice Stevens and Justice White's dissent, essentially what they're saying is they think that personal jurisdiction would be unfair in this case. They said all the business took place in Michigan, which I think is true. The principal contacts with the Michigan office, so there's no notice that the distant corporate headquarters would seek to assert jurisdiction in Florida. Number 3, they said, look, the defendants have no real contacts in Florida, right? These 2 justices, they're like the negotiations are out of the Michigan office, which is true, right? The clients are in Michigan, and the supervision that is done over the franchise is from a Michigan office. They're like, there's not really any real contacts with the state of Florida. They're like, this is a wrong decision, right? Justice Stevens and Justice White also say the real question they should ask is whether the defendants could have anticipated being held into a Florida court to be sued, and they say no. So these 2 justices are saying, even though, yes, they entered a contract with the Florida corporation, we get that, but all the dealings were done in Michigan, so they're thinking if there's any issue that comes up, legal issue, we'll dispute it in Michigan. The contract is negotiated here, we're supervised from the state of Michigan, we live in Michigan. Like, we didn't think we'd have to go all the way to Florida to defend ourselves. Who agrees with Justice Stevens and Justice White? I think it's a really, really strong argument. Yeah.
Concerning fairness, I also disagree, because even though these guys were savvy businessmen, they also just lost a business with considerable assets. And if, like, as policy, we want to encourage people to take those chances and start new businesses, I think in fairness, we should also maybe lean more towards them.
And my counter argument would be, if I were your co-counsel, not co-counsel, but opposing counsel, I would say, not my problem if they didn't manage their fund. They breached the contract, so I'm not going to make it easy for them when they're the ones who breached the contract. They didn't uphold their responsibilities. I'm the one that's getting screwed. My client is getting screwed. So why do I care about, your ability to come and defend yourself?
Because it was an economic downturn. Maybe it wasn't that they didn't manage it, but it was,
It's their responsibility to anticipate changes in the market and to make the adjustments. They didn't run their business well, and now they have to be held accountable.
Well, the government doesn't always manage its business well, but then it kind of takes
Don't
up
say
for
that.
itself after.
That's a judge. Don't bash his boss.
His boss is supposed to be the
I was
people.
gonna say that the economy was probably fine in the 70s in Michigan. Automobiles were good.
Oh.
It was before crack hit and stuff. Michael Jackson.
Wow.
Running out of time. Attorney
I would
Beth.
just say, I think the problem may have been that not necessarily they didn't run the business well, they wanted to run it their way. Because I know I worked in McDonald's for like 3 years and was a manager and everything, and they have a firm hand on everything going on, and it's best just to do what they say because they know how the
They
market's
know
gonna
how the
change.
market runs.
So if you're disputing with your parent company about everything going on in the restaurant, it's not gonna go well.
All right, we've run out of time, so I will start the class out on Monday with the black letter law to make sure you have the takeaway from Burger King, and then we'll do the Pavlovich. So I'm starting to see now, it looks like we can handle 2 cases a class, so I'll adjust the views, so I'm trying to figure out how fast we're moving. All right, have a great week. Stay warm. And I'm in my office all day today, so we're stop by.
Until what?
It was just, I'm just tossing shit.
Yeah, I just opened it up. You have extra room. Huh? You have extra room.
Thank you.
Well, at least you. At least you. Yeah.